Right, good morning, everybody, and thank you very much for joining us. Welcome to all of our homes under what continues to be challenging conditions. My name is Chris Charter. I am head of the competition law department at Cliff Decker Hofmeyr, and welcome you all to this short but I think pressing webinar on some of the key policy developments of late in regard to ownership and transformation through various policy initiatives that the Minister of the Department of Trade, Industry and Competition has launched recently. Just quickly to introduce our panel of experts. We have Narsha Lupu, who is a long-time colleague of mine. She still lives to tell the tale, though, in our competition department, who will be taking you through some of the competition law specific policy developments. Also have Ryan Allo, who is a competition, a corporate and commercial partner, and he is supported by Varishka Pillay, who many of you will know, a venerable partner in our corporate and commercial department with a particular focus on Black economic empowerment. And most of you will have come across Ardil Patel, head of our employment department, who most likely needs not too much of an introduction, and he will round up our discussion on some of the developments on the employment side, which speak to some of these policy trajectories. Just by way of some very quick housekeeping, I think most of us are now familiar with these virtual formats. Teams does allow for our audience to weigh in with questions. You should find a button which will allow you to participate in Q&A. So please do feel free to send through your questions as people are talking. And towards the end of the webinar, if time permits, we'll try and cover as many of those questions as possible. Of course, if time doesn't permit, or if you put us a little bit on the spot, this is not the last opportunity to engage with us. So please, if you've got any burning questions which we didn't get to or didn't get to adequately, please feel free to send those through to the CDH events website, or of course to contact any one of our experts on the call today, or failing that, whatever pet favorite CDH lawyer you have on speed dial, we'll be able to direct your query appropriately. So just before I hand over to Narsha as the first speaker, just to maybe set the scene as to why we're bothering you with all of this morning. I think, as anybody is now aware throughout the world, policy is very much the currency of the modern political state. And in South Africa, it's no different. We also know that our economy is beset by economic concentration and ownership concentration. With apologies to a well-known colonial, to use his words against him, never before have so few owed so much to so many, in all the wrong ways. And I think that has certainly been a key policy debate since the beginning of democracy in South Africa, has been how to develop a more inclusive economy. And that policy has gone by many different labels over the years: affirmative action, Black economic empowerment, radical economic transformation, and laterally the slightly less incendiary term of transformation. And of course, policy in any modern state begets laws. So we have BEE legislation, we have employment equity legislation, we have competition law, which covers the twin peaks of ownership concentration and economic concentration in the interest of promoting competition. And then we have other legislation which chips in. The Companies Act places certain obligations on triple bottom line reporting. We have the King reports, requiring other disclosures, and all of these things are moving around from policy perspective. So the policy gives us the laws, but of course the laws need to be enforced. And in that way, we have commissions of inquiry, we have all sorts of policy makers and policy developments within the legal paradigm, and that's really where things become perhaps more interesting, because as much as the laws are immutable, the policy keeps shifting. Maybe a useful analogy is to think of the rules of the road. We all know what the speed limit is. We know that you can't drive more than 40 kilometers in certain zones, and we know when the speed limit is 120 kilometers. But how we actually drive is more influenced by the policy. In other words, if we know the sheriff of this here town is going to be throwing the book at us in terms of speeding fines, we'll drive a lot more carefully into the speed limit. If the sheriff says, welcome to our town, have a good time, please just drive carefully, we will operate in a slightly different way. So business in reality operates in a policy environment. So it's all very well to understand the law, but almost more key from a day-to-day perspective is to understand the policy. The South Africa reality has been difficult over the years. We have a cabinet that hardly ever speaks with one voice, and yet there are a lot of cooks in the kitchen when it comes to policy development. But what we do have recently is probably the most powerful organ for developmental policy, at least, and that is the Department of Trade, Industry and Competition under Ibrahim Patel, who everybody knows is a past master at designing policy. We might not all agree with his policy trajectory, but he certainly is a policy guy. And coinciding appropriately with Workers' Day this year, Minister Patel went on pretty much what you could consider a policy drive. He introduced a press conference on ownership in the competition space, and then he proceeded to publish a number of policy documents, including a new practice note for broad-based ownership schemes, a competition policy on jobs and industrial development, and this obviously accompanied a policy statement on localization and industrial growth, and he's also mentioned possible amendments to the Companies Act on worker compensation and board representation, all of which is a clear indication of the kind of policy strings that the department will be pulling. And the department does cover a lot of ground. If you were to look at the DTIC's manifesto on its website, it has first of all, a very ambitious vision to build a dynamic and industrial, global competitive South African economy, characterized by meaningful economic transformation and inclusive growth and development, decent employment and equity, built on the full potential of all citizens. It's pretty stirring stuff. How are you going to do it? What is their mission? Their mission is to promote structural transformation. It's to provide a predictable, from your lips to God's ears, competitive and equitable and socially responsible environment which is conducive to investment, trade and enterprise development. A key part of the mission is to broaden participation in the economy, and finally to coordinate the contributions of government departments, state entities and civil society to effect economic development. So it seems to us, at least, that the DTIC has taken on board the mantle of really driving extremely broad industrial policies. But what the minister has done, to his credit, is to become very transparent with his policy trajectories. So he's published policy documents which all of us can read, sometimes read and weep. But one thing is for sure is that nobody can really easily say, I had no idea the policy was headed in this direction. And I think it's against that background that we thought to regale you for a few moments on some of the key developments in those areas of the law and policy, being Black economic empowerment, competition law and employment, where a lot of these policy debates are being at last drawn together. So without further ado, I'd like to hand you over to Nasha Lupu from our competition department, who's going to spend a couple of moments taking you through the developments from that angle.
Good morning and welcome. I would like to give you an overview of the key policy documents released by the Department of Trade, Industry and Competition, discuss some of the key major decisions, and end off with some practical pointers. So on the eve of the Workers' Day celebrations on 1st May 2021, the Minister of Trade, Industry and Competition, Mr. Ibrahim Patel, held a press conference with business leaders and trade unions to discuss worker ownership structures. The minister was pleased to announce that more than 150,000 South African workers are now owners of companies they work for. Government has identified worker empowerment through ownership structures as a key foundation to unlock inclusive growth and alignment between shareholders, management, and workers. In his budget vote address a couple days later, the minister said that ownership alone is not enough, and something more is needed. He suggested that worker ownership structures should not take the form of passive stakes in companies. Instead, he would like to see more worker representation at corporate board levels. To achieve this, the Minister also announced the following imminent changes. 1. Within the next couple of months, we can expect to see an amendment to the Companies Act that will set out models for improved worker representation on board levels. 2. The IDC has championed the use of worker ownership structures in their portfolio companies to drive transformation. And lastly, the department is currently working on developing a register containing the details of worker ownership structures, the first of its kind. This all sounded the warning bells that Minister Patel means business. And in the ensuing days in May, this all became much more clearer, as we have seen a suite of policy documents being released by the department, all of which have the underlying objective, amongst others, to build a new model of economic inclusion that unites South Africans in the economy and promotes transformation. On the 18th of May, the department published the very first policy statement on localization for jobs and industrial growth. In this document, it has been noted that South Africa has an overpropensity to import goods which could otherwise be produced locally. This particular policy centers around localization, and the goal here is to build industrial capability for local and export markets, thus creating new jobs and opportunities for a greater number of South Africans, including small and medium businesses owned by the women and children of our land. Closer to home now, and interlinked very closely with the first policy, the department published the competition policy for jobs and industrial development on 19 May. Now, this policy has several laudable objectives. For instance, it aims to address the high levels of economic concentration, protect and create jobs, and promote transformation. In particular, the policy notes agreements reached between merging parties and government using the provisions of the Competition Act have produced significant developmental outcomes in a range of areas and will provide a guide to the market of the kinds of concerns that policymakers will explore with merging parties relating to, for instance, employment, broad-based ownership, supply development and localization, investment and downstream beneficiation. I now would like to touch base on a couple of cases where we have seen that the Minister and together with the competition authorities work together to carve out and create a number of conditions that relate to the public interest under the Competition Act. So the first case deals with PepsiCo. So in March 2020, PepsiCo was given the green light to acquire Pioneer Foods, subject to certain public interest conditions. These were as follows. For instance, number one, there was a moratorium on merger-specific retrenchments for 5 years, coupled with a further commitment that the merger would create new jobs. Secondly, the merging parties committed to invest 6.5 billion rand to maintain and expand South African operations over the next 5 years. Of this, 600 million rand was set aside to establish a development fund. And this development fund has been used to facilitate the entry of farmers and small and medium-sized businesses in the supply chain. And the third condition is by March 2021, the workers of the company should have been issued with 13% of the shares in the company worth 1.6 billion rand. However, the Competition Tribunal earlier this year agreed to extend the target date from March to September 2021 due to the COVID-19 pandemic and the national lockdown. In addition, the merged entity agreed to provide 55 million rand as compensation for any potential economic prejudice to workers during the 6-month extension period. The next case that is of interest concerns the Coca-Cola Beverages South Africa merger, in which Coca-Cola Beverages South Africa applied to the Competition Tribunal in February this year to vary the merger conditions that were imposed in two mergers that had taken place in 2016 and 2017 respectively. In those two mergers, there was a requirement that the merging parties had to increase the BEE ownership of the company to a specific percentage by May 2021. And in the variation application hearing, the parties submitted that this condition could not be achieved in time due to the COVID-19 pandemic. The variation was granted by the Competition Tribunal, and following that, we had seen that the company, Coca-Cola Beverages South Africa, worked quite closely with the Minister to design and implement a worker scheme which would provide approximately 8,000 workers with a direct stake of 15% of the issued shares in the company, together with representation on the board of the company through 2 worker-appointed trustees. In addition, the Competition Tribunal were also able to extract 2 further public interest obligations relating to localization and procurement, all of which would benefit small and medium-sized sugarcane farmers. In March 2021, the Competition Tribunal conditionally approved the merger, whereby Mr. Price would acquire the retail apparel business operated by Otto Brothers Distributors, trading as Power Fashion. In this merger, the parties agreed that Power Fashion will maintain or improve its current level of locally procured goods and services, and secondly, that Power Fashion would participate in the department's retail, clothing, textile, footwear and leather master plan initiative along with the rest of the Mr. Price Group. All of this seems to be driving and promoting localization. The next case I'd like to talk about is the merger that had taken place between NMI Durban South Motors and Barloworld Motor Retail Business. This merger was approved by the Competition Commission and by the Competition Tribunal in May 2021 with the following public interest conditions. The first one was the merged entity shall continue to participate in the Barloworld Supplier Development Program for a period of 2 years. And during this period, the merged entity should develop its own supplier development program. So on the other end of the spectrum, we have recently seen that the Competition Commission has prohibited the merger between, on the 1st of June 2021, where a private equity firm, ECP Africa, intended to acquire Burger King from Grand Parade Investments. The Commission found that the target firms are ultimately controlled by an empowerment entity where historically disadvantaged persons hold an ownership stake of more than 68%. The acquiring firm, on the other hand, ECP Africa, has no ownership by historically disadvantaged persons. In post-merger, the Commission found that the merged entity would have no ownership by historically disadvantaged persons, and this would lead to a significant reduction in the shareholdings by historically disadvantaged persons in the target firm, having gone from more than 68% to a mere 0%. It is still early days, and we are not certain whether the merging parties would take the matter on reconsideration to the Competition Tribunal, and we would have to watch the space more closely. So, from all of these cases, one thing is quite clear. It seems that the competition policy signals a greater involvement by the Minister's office in merger regulation, especially since the Minister now has an automatic right to participate in merger proceedings where any of the public interest factors are affected. So from a practical perspective, it's quite important for deal makers to consider how their transaction can be structured to advance the public interest goals in the competition legislation and the competition policy. And it's quite important for the deal makers to build in these structures, to consider the cost to set up these structures, and all of this needs to happen at the outset. And in doing so, the timelines for investigation, engagement with the competition authorities and subsequent approval of the merger are likely to be expedited. We would, merging parties or deal makers would avoid the back and forth that take place between merging parties and policymakers, and an early engagement with these issues, coupled with reaching an agreement between merging parties and government, have proved to make for a much more easier passage. So from all of this, it appears that the Minister and the competition authorities are ready. The question is, are you? I'd like to now hand over to Ryan, who will talk you through the some of the B-BBEE components. Thank you.
Thank you, Nasha. One of the hot button topics in the BE space of the past few years has been the interpretation of the BE codes as they relate to discretionary collective enterprises. This is a new term of art used to describe broad-based ownership schemes, employee share ownership programs, not-for-profit entities, trade unions, and trusts. Discretionary collective enterprises is a bit of a mouthful, so I'll just refer to them as DCEs. Despite the widespread existence and creation of DCEs, since pretty much the inception of the BE codes, based on the fact that the code specifically recognized such ownership vehicles, the BE Commission has displayed increased skepticism when it comes to certain structural aspects of such entities. This skepticism has increasingly been accompanied by increased levels of scrutiny, which the BE Commission has brought to bear when assessing major BE transactions, as well as through other engagements with transaction participants. In 2018, the BE Commission released the guidance note on DCEs, which sought to impose additional structural requirements for DCEs that are not present in the BE codes and which are legally questionable. Since then, the BE Commission has also publicly announced that certain transactions which include DCEs are not compliant with these additional requirements and therefore do not constitute genuine black ownership. Understandably, this created enormous uncertainty and consternation for existing DCEs and poured cold water on proposed transactions which would have included such entities. DCEs, corporates, and other stakeholders were left in the untenable situation where the BE codes set out clear rules for both the establishment and recognition of such DCE entities, but the Commission was applying a parallel and different sets of rules. To be fair, the BE Commission's objectives in this regard were laudable because they were responding to the fact that such entities are open to abuse. We've certainly seen many instances of structures containing DCEs which are dubious. However, the Commission's approach in this regard did have certain unintended consequences. An example of this concerns family trusts. Now, as we all know, family trusts are a common estate planning tool, which ultimately find their way into many ownership structures. However, given the BEE Commission's approach to trusts as an ownership vehicle, many ownership structures which included family trusts received undue scrutiny. Another example concerns long-standing broad-based ownership schemes with proven track records of benefiting Black people that were asked to change the way in which they historically operated on a basis that was legally questionable. Thankfully, this long-standing uncertainty has been alleviated by the Minister issuing a practice note on DCEs, which specifically addresses the manner in which DCEs should be interpreted for purposes of BEE legislation. While we won't go into the granular detail of the practice note in this forum, the primary takeaway is that DCEs have expressly been recognized as valid ownership vehicles for purposes of BEE. What we would like to unpack are the apparent policy reasons behind the issuing of this practice note and what this says about the policy elements that the Minister is seeking to prioritise. It's clear that the Minister sees particular value in worker ownership schemes and considers them to be an important means to improve industrial relations within South Africa. What's interesting here is that neither the BEE Act nor the codes express any preference for any particular form of ownership, whereas the Minister's comments certainly can be seen as an express endorsement for worker ownership schemes in particular. This could also be seen as evidence of the Minister attempting to align BEE legislation with broader public interest considerations under the Competition Act, as Nasha had discussed. There are several aspects of the Minister's remarks on worker ownership schemes which are worth taking a deeper dive into, and the first concerns the ownership element. Here, the Minister has specifically earmarked evergreen worker ownership schemes as an important tool for improving broad-based empowerment. Now, evergreen schemes are characterized by the fact that the shares in the measured entity are held by the scheme itself and not directly by the scheme participants. An interesting aspect of these evergreen schemes is that the economic benefit granted to participants is typically limited to dividends. In contrast, many traditional employee share ownership schemes on the basis of maximizing incentivization entitle participants not only to dividends, but also to capital growth upon exit from the scheme. In practical terms, this simply means that the participants are entitled to realize value once they dispose of the shares issued to them under the scheme. And given this limitation of evergreen schemes, it's interesting that they have received specific endorsement from the Minister. And we're quite keen to see how this particular policy agenda is advanced in the future and how it plays out. As Nasha mentioned, the Minister has also emphasised that worker ownership schemes should be accompanied by appropriate worker representation on company boards. This is also an interesting statement and an interesting component because generally board representation is based on the extent of shareholding. So for instance, if you had a worker trust that only owned 5% of shares in a company, you wouldn't expect that trust to have a seat on the board. This leads us to question the legislative changes that will accompany this policy agenda, and the Minister has already mentioned that we can expect amendments to the Companies Act in this regard. This also has some interesting, raises some interesting issues from an employment law perspective, which I'm sure Adil will address later in this webinar. Perhaps the final point to note in relation to the practice note is the generous approach that it takes to DCEs being able to recognize Black ownership. What the practice note says here is that even if a DCE does not comply with all of the rules in the BEE codes, it will still be able to recognize Black ownership. This is an interesting departure from the approach historically taken by the BEE Commission, which were quite critical if you didn't tick each and every box. We can certainly expect more from the Minister in relation to BEE, as he's made clear that further steps need to be taken to address BEE-related issues that were not dealt with in the practice note. Here, the Minister specifically referred to fronting practices, funding mechanisms, and general challenges in corporate governance. The Minister also mentioned that he is going to constitute a panel to advise him further on these additional areas of concern. This may lead to additional practice notes being issued, and by extension, changes to legislation, and not only the BEE Act, but also the Companies Act and other legislation. And we'll certainly be keeping a keen eye out for that. All things considered, and just to close, we consider the practice notes to be a very welcome step in the right direction. The Minister no doubt sees the value of DCEs in the economy and in our markets, and has sought to free the legislative landscape from some very challenging and problematic issues of interpretation. I now hand over to Ariel Patel to speak to you about the labour law implications.
Thank you, Ryan. Firstly, a disclosure: I am not related to Minister Patel. Two is Minister Patel comes from the trade union movement. So what you're finding in the practice note is what is termed a democratization of the workplace. And how is he trying to do this? He's trying to do this through BEE legislation. And what is he saying to you? He's saying to you, as part of BEE legislation, you should consider worker representation on boards of companies. And you're thinking to yourself, wow, what a novel idea. My workers are going to be able to tell me how to run my business. But it's not a novel concept. It's a concept that emanates from a first world country, and it is fairly entrenched in Germany. What you need to ask yourself, independently of BEE legislation, is whether we are in a market which is sufficiently mature to allow that to happen. But it's not only from the capitalist that we need to look at this aspect, but whether workers sitting on boards of companies are able to effectively represent employees. And colleagues, I think that is a more fundamental ideological and philosophical discussion which you're going to need to grapple with as an organization independently of the practice note and the legislation. And you need to then determine whether that is the appropriate method which you wish to achieve compliance, or you wish to achieve some sort of compliance with the BEE legislation. You would have seen in this morning's paper, the BEE Commission has said that on paper, there's been a slight increase in the black ownership of our structures. However, those are not filtering down to our lower levels, and to use the euphemism that she has. And she calls this fronting, and she's calling for more investigative power so that she can investigate whether the real effects of empowerment are felt throughout. So simply having worker representations on boards, which is laudable and mirrors what's happening in Germany, and will certainly lead to the democratization of the workplace. You need to understand whether you will be able to, in substance, ensure that workers have an effective voice on boards. So that's the first aspect of the practice note that I want to talk to you about. The second thing is employee share ownership schemes which are limited to black people as defined in the BEE legislation. On face value, there's an inherent conflict between the Employment Equity Act and the Broad-Based Black Economic Empowerment Act. Act. So one, the Employment Equity Act uses the word designated groups, and it says black people, including white women. The BEE legislation excludes white women. Now, there are a number of challenges that you may consider. Step one is it discriminatory insofar as I have an employee share ownership scheme limited only to black people? It's acceptable in terms of the practice note. It's acceptable in terms of the BEE legislation. It's acceptable in terms of the Constitution because the BEE legislation tries to give content to the right to equality. You then have the Employment Equity Act, which says you cannot be discriminatory. However, you can be discriminatory insofar as for the purposes of affirmative action. Doesn't deal with employee share ownership schemes. So you have two pieces of legislation trying to give content to the right to equality. And you need to try and marry those two pieces of legislation because the Employment Equity Act says that it takes precedence unless it is in conflict with the Constitution or any express legislation, any legislation that expressly amends it. Now, the question that you need to grapple with, and there's no reported cases on this as yet, there is some litigation in the Labour Court dealing with this very point as to whether employee share ownership schemes which restrict participation to black people only is discriminatory. And the question that you need to ask is, firstly, it differentiates between white colleagues and black individuals. But is it discriminatory? And the question that you need to ask yourself is whether, when this is challenged, and challenge it will be, as it is currently is in the Labour Court, and you would note also that during the COVID pandemic, the Minister of Tourism is being challenged regarding her fund which he has created for black professionals only, whether that is discriminatory and whether you are going to consider litigating on this very topic. With that issue, I leave you to consider two things. One, are you going to allow employee representation on boards? Two, what are you going to do with employee share ownership schemes which restrict it only to black people and the potential for litigation? Thank you. I now hand over to my colleague and the moderator, Chris Charter. Thank you.
Chris, you live?
Thank you, Krishka. Thank you, Adil, and to the rest. I think that's really good food for thought, and I think sets the scene nicely for the last 20 minutes or so of this webinar, where maybe we can get stuck into some of the sort of key implications of the various policies at the various levels. I see from the Q&A that obviously you know, the current elephant in the room, and we're used to elephants in Africa, is the recent Burger King and Grand Parade decision that came out from the Competition Commission. That decision obviously throws into stark relief, I think, both the policy itself on BEE from a merger control perspective, and the fact that the policy is one that's going to be driven quite hard by the competition authorities. I will say that, of course, that decision has just come out from the Commission. It's still essentially a pending case, because the next step could very well be for the parties to take that through to the Competition Tribunal for a reconsideration. But certainly we need to recognise that the decision does send a particularly strong signal to the market about how seriously the policy is taken. To the uninitiated, it will come across as a very binary decision. And I think there are some key questions that will probably be on a lot of deal makers' minds. And chief amongst those will be to say, what happens if we are involved in a transaction which of necessity, due to the commercial nature of the transaction, will reduce Black economic empowerment levels? And that is often the case with foreign direct investment, which obviously is something that we need to encourage. It could be just very much based on how difficult it might be in certain industries to get significant Black investors involved. There's a lot of industries where one might generate higher or lower returns, and some are therefore more attractive to sort of Black industrialist investors. And sometimes it's the simple fact of we've paid all the money, and it's very hard to wrap our mind around about giving up what we've paid for. So there are often challenges around Black economic empowerment. So maybe Narsha, if I could ask you, without asking you to comment specifically on the Burger King case, what advice would you give to two parties who are embarking on a merger, where a diminution of Black economic empowerment levels has been identified? What are the options?
Hi, Chris. Thanks for that. I think for me, I think the key point of departure is about planning. So it's quite important for deal makers to really get stuck into the planning quite early on. I think secondly is that they, instead of actually putting up a condition aimed at specifically BEE ownership, they could be a suite of other commitments that merging parties could put up to so-called sweeten the deal. And what they could also do as a third point is that they could think about putting up, some sort of undertaking or commitment to maintain the BEE levels, or they could put a plan to try and improve the BEE levels over, for instance, a period of time, be it 3 years or 5 years. So I think for me, it all comes down to planning. It all comes down to pricing in the cost, and all of this needs to happen at a very, very early stage. Thank you.
Thanks. Thanks, Narsha. Just to pick up on that a little more now. Obviously, the simplest is to say that whatever the current Black economic empowerment is, we will maintain, and certainly that's going to be the path of least resistance in many deals. The problem, of course, with the exiting parties and the acquirers in the Burger King case had, was that it was essentially a Black-owned company which was exiting in favor of a foreign investor who obviously is not Black-owned, which means that quotient of 68%, as you pointed out, goes right down to zero. Do you think there is scope within the minister's policy to put a proposition together of a far lesser Black economic empowerment number, and supplement that with other public interest benefits that the merger might bring?
Yeah, so I think, Chris, to answer your question, definitely. I think what merging parties could perhaps start thinking about doing is to think about starting at a lower number, for instance, at 5%. Starting with that as your opening gambit, and then building on other commitments, for instance, supply development funds, or putting together some sort of skills development, especially for small businesses, women and children, for example, in the form of bursaries and scholarships. I think all of those together packaged would kind of the tables the other way towards a conditional approval as opposed to a prohibition.
Great. Thanks, Nash. And I would only add to that, I think that if one reads the minister's policy document, it's very much in a tone which suggests that what the minister is looking for is for merging parties to come to the table with a proposition. And I think what has been the hallmark of the public interest sort of trajectory under merger control at least has been agreed conditions. And it seems to us at least that the minister is very much alive to the fact that what he would prefer is an agreement. And you know, if you have a suite of public interest benefits, a lot of those are oftentimes sort of levels of investment in value chains, etc., which possibly was already part of the strategy, and to convert those into public interest commitments is a really good way to get the minister on board to help sell your merger under his policy. So the worst thing that emerging parties can do is try and stonewall the minister and the Competition Commission in regard to the policy. Instead, it makes sense to engage on that policy and find ways to reluctant to use the word pay lip service to the policy, but to show buy-in to the policy in such a way that overall the Commission can say we have followed our mandate to make sure that this merger overall benefits the public interest. Maybe just to segue from that, and obviously one of the big issues out of the most recent case and a lot of the cases before that is what kind of a signal it sends to foreign investors. Varushka, maybe if I could ask you, in this regard, it's important obviously to draw balance between a very important transformation policy agenda in South Africa and not scaring off foreign investment. You know, our BE laws are obviously a lot stricter and a lot stronger than looser sort of affirmative action type things in other economies. Do you think that the minister, in terms of his policy statements, is drawing an appropriate balance between transformation, driving that agenda, and encouraging foreign direct investment?
Thanks.
You live, Varushka?
Thanks, Chris. I think that the minister's statements are helpful to understand the direction that he would like to see this going in. I think that there remains a disconnect between what the BE codes entitle companies to do in relation to ownership and how that is actually measured, in the sense that multinationals in particular have certain ownership options that are not necessarily catered for in terms of the Competition Act. The Competition Act speaks very specifically about ownership by historically disadvantaged persons, whereas in terms of the BEE codes, as an example, multinationals may implement an equity equivalent program, which is an option to actually pursue an alternative to actually disposing of shares. And what we find is when the multinational then is faced with a merger that has to be approved by the Competition Commission, it seems that option then falls off the table. And that is an inconsistency in the way in which BE policy then plays out in the market, something that we think needs to be looked at and dealt with more appropriately. It does lead, to the situation where a multinational who actually isn't in the space of having to have a merger approved then has those other equity equivalents available to them as options. Chris, while I think that's all on that particular point, but would you like me to address any of the other questions that have come through on the Q&A while I have the floor?
Yes. Yes, please. I don't know if I think everybody can hear me as well. Yeah, I think there's quite a few questions coming out in terms of trying to reconcile various bits of BEE policy which have come out over the years, and there are various sector requirements. Someone has mentioned the ICT sector with new regulations on 30% Black ownership, and of course, you know, we've various sectors have got their own BEE charters, which are it seems to me constantly being litigated on. But do we have a situation? I mean, if you can address those questions as you see fit, but overall, do we have a situation, do you think, where the minister is working towards kind of unifying some of these policies, and in particular, does the practice note introduce any fundamental changes in terms of what has been on the table previously? We may have lost
yes.
Mariska briefly. Mariska, you are back.
Am I back? Oh my.
I hope it wasn't that difficult a question.
Sorry, thanks, Chris. So what the practice note does is, in fact, address very key matters that had arisen from the interpretational difficulties that Ryan mentioned had arisen through the BE Commission's commentary. In fact, they issued a guidance note as well in 2018 on all of on the DCEs and how they should be, how the BE Commission interprets those particular structures should operate. The practice note deals with the very material items relating to things such as can minors actually be beneficiaries of family trust or any trust, whether it's a broad-based trust or a family trust? And that's been made clear that they can be. Should beneficiaries of trusts actually have the right to vote on matters where the trust and the trustees, in fact, are the custodians of the shares in the underlying company? The BE Commission's view was that beneficiaries should, in fact, have those voting rights. The practice note says clearly that it's accepted that the trustees are the fiduciaries and they make the decisions in that regard. In regards to, interestingly, then coming back to the worker trust, the BE Commission had been very clear that they would expect employees to be represented on the board, and there does seem to be alignment then with the minister's thinking around that, and the suggestion that there will be some amendments to the Companies Act to address this. It may not be compulsory, but we'll have to see what comes through in the legislation. Abigail, I think there has been a significant U-turn in respect of how DCEs have been viewed by the BE Commission, and the practice note alleviates many of the challenges and results in us being able to recognize them appropriately for BE compliance. I think the other thing that we do need to be mindful of is that the practice note in its introduction suggests that there will be further changes coming to tighten, I think, particularly the concerns that the Commission has had around fronting. And so we must just watch that space for any further changes. Nothing was mentioned in respect of the modified flow-through principle in that practice note, to answer a question that also is there in the Q&A. And lastly, coming back to policy inconsistencies, Chris, in the context of the ICT sector and the changes that have been made, the regulations that were published arise from ICASA's inquiry into how to address BE in that space, in the ICT sector space. There's a historical provision in the Electronic Communications Act around 30% ownership by historically disadvantaged groups, and ICAS has gone through a long process of investigating how to deal with that particular requirement in the context of the ICT sector codes having come about. I think that the regulations now saying that 30%, that there should be 30% HDG ownership or 30% Black ownership as measured in terms of the BEE codes will mean certainly the 30% Black ownership measured in terms of the ICT sector code, I should say, will mean that DCEs will be recognized and can be used. But I think in the ICT sector, you just need to be aware that that particular requirement has been suspended in terms of the regulations. I think that sums up the various questions so far. It's enough from me on CE for now. Thanks.
Thanks, Veriska. I'm going to just keep you on the spot for just a couple of more seconds if I can ask you one other question. Now we have BEE, and we'll come up in two contexts. There's the overall BEE context, which is a running obligation to empower, and there are certain levers that the BEE codes and government procurement policy, etc., uses to drive that. When you're faced with a merger, then that's yet another lever that the minister is able to pull in order to drive certain transformation objectives. And I was wondering if you had picked up on any obvious mixed messages. In other words, are you finding that complying with the minister's policy on competition law in the merger scenario and the messages being sent and what you need to get that over the line from a BE perspective or an ESOP perspective is different to what is required to comply in the ordinary course? And are we seeing, is there hope for some more alignment on that?
Chris, yeah, I think there is still some we do see some inconsistency from a BE perspective. Often companies are faced with pressure to have a particular BE compliance level for their customers or perhaps for their licensing requirements. There may be some need then to have a particular ownership level, as was mentioned in terms of the ICT sector code, but that is not commonly the case. And the Competition Act focus on ownership specifically does skew things somewhat, in the sense that particular ownership may not necessarily be required for BEE compliance purposes. It may be that the BEE compliance level that's required for that particular business doesn't warrant the level of ownership that perhaps the minister is looking for. It's also the case that, as Ryan mentioned, BEE ownership structures can take one of several forms, and the focus on an employee ownership structure may not necessarily work for that particular business. So I think that we have seen those tensions arise. It will be interesting to see, and hopefully this is a signal of some level of alignment, having seen the practice note come out, and also in the context of the various other policy statements that are being made, that there may likely be changes to specifically the BEE legislative space, so that there is more alignment.
All right. Thank you, and I think that's obviously would be ideal. I will just we've got literally a few seconds left, but I think maybe just a couple of takeaways. I think the first thing to realize is certainly in a deal making scenario is that the policy that the minister has published is increasingly clear about the kind of things that merging parties should be looking at when trying to justify their merger in the public interest, which is a clear test under the Competition Act's merger control provisions. And I think, as Nash has pointed out, a key issue here is going to be to try and early on get to grips with what is the current benchmark with regard to BEE and owner participation in your company, whether the merger will change that, and of course then if there is any opportunity to maintain it or improve it, to the extent that there are difficulties in maintaining or improving a level of BEE ownership or employment participation. There are other buttons to push from a public interest perspective, and the minister has clearly signaled that he'd be open to agreeing a suite of conditions which overall provides a benefit. But all of these things do take time. We didn't have time to ask Varushka, but I do know that, you know, to put together a decent, well thought out, tax efficient and compliant BEE structure does take time. So this is not the kind of thing you want to be trying to negotiate with the Competition Commission of all people at the very last minute, and that is where things tend to come unstuck. But there are ways through here on employment in particular. As Adil has pointed out, there are you know, a developing paradigm. I will say that in terms of worker participation, the Competition Act and the minister has been very careful to toe the line. There is a definite, there are two different issues in the Competition Act. There is ownership spread by previously disadvantaged individuals on the one hand, and worker participation on the other. So from a discriminatory point of view, certainly our perception from the competition side is the minister has been quite careful to separate the two out. And in fact, that gives you yet another button to push. You may not be as strong as you would like to be on black ownership, but you can be stronger on worker participation. In that regard, the minister, at least in the competition milieu, has tended not to weigh in on whether your worker participation is black or white. He's been careful to say it's about ownership participation generally, and I think it does remain to be seen, as Adil pointed out, whether that is going to improve things significantly, greater worker participation, board representation, a la the German model, whether that can and will work here. But certainly, and I think this might be the final word on the subject for now, is that the policy continues to develop. And I think it should be welcome that Minister Patel has been willing to put pen to paper and actually publish the policy. I think the key issue, of course, is that if the policy isn't working or is heading in the wrong direction, for that policy to change and change quickly. So what we really need from our policymakers is for them to be fleet of foot, to recognize a lot of the stakeholders, both within our borders and outside of our borders, recognize their views and bring those to bear. So I think we can all be one for introducing new policy. The worst thing you can ever do is to do nothing. But the key thing is to make sure that you're willing to change that policy or at least adjust it if it's not working. So I think it's a step in the right direction from the minister to be a little bit more transparent on policy. Hopefully he will remain open to discussion and debate. And I think there was one comment on the Q&A which I think is worth signing off with, and that is just the need to really understand the fact that the Department of Trade, Industry and Competition does have its fingers in a lot of pies when it comes to business and business development in South Africa. So you really do need to engage with the minister's policy, see where you can buy into it, send the right signals, and on some of those big deals, bring the minister in early, so that you can get buy-in from him and his department and the various strings that he's mandated to pull through his department mandate. Thank you very much. We've gone just a little bit over time. I wish we had more time to discuss some of these things, but they're absolutely worth discussing. So anybody on the call who wants to pick up on some of the issues relevant to their business, or if you've got plans in the pipeline to make sure we are all headed in the right direction, please don't hesitate to reach out to any of us. And this is the kind of thing we do love to talk about, and these are the kind of problems that we do love to solve. So thank you very much to all of our speakers. Thank you to everybody behind the scenes to make it work, and thank you very much to our friends on the call for listening in. And I hope to speak to you again soon. Thank you.